SLAPP stands for Strategic Lawsuits Against Public Participation. Basically, meaning where somebody files a lawsuit and it's strictly strategic. Like it's not really, they don't really have any real legitimate basis for it, but all they're trying to do is try to prevent someone from participating in the public. Usually it has to do with it. It's a First Amendment issue. So I've seen people, file a lawsuit against somebody for filing a lawsuit. Um, that's pretty squarely in somebody's First Amendment right to petition their government. But in California, what happens is there's a very specific mechanism, which is called a special motion to strike. Now, generally speaking, when somebody files a lawsuit, they file a complaint, then the defendant can respond either with an answer or with a motion to dismiss. Along with a motion to dismiss, they can also, or separately, they can also file what's called a motion to strike. Motion to dismiss basically means to dismiss the entire complaint. And in state court in California, it's called a demur and not a motion to dismiss. A motion to strike usually is going to be directed specifically at specific causes of action. So in this case, they're count 1, count 2, count 3. So it would be a motion to strike, that would be addressing specifically 1 or 2 or all 3 of them, even to see if, maybe the court doesn't want to dismiss the entire case, but maybe they would want to dismiss 1 or 2 of the causes of action because it's just 1 or 2 too many. But in California, for an anti-SLAPP, you have a special motion to strike, which basically would undermine the entire lawsuit because you're saying this lawsuit was filed for improper purposes. It was purely strategic, and it's purely to basically infringe my First Amendment rights. And it's very very specific. Somebody files an anti-SLAPP motion, and what happens is everything stops. There's no discovery in the case. There's maybe some limited discovery only for the purposes of like the motion practice for the anti-SLAPP, because sometimes in order to respond or to like fully flesh out the issues for the anti-SLAPP, you need some discovery. So sometimes courts will allow that, but generally speaking, the entire case freezes until you resolve that issue, and it happens very fast. And then you have attorney's fees that go to whichever side wins, because it's a very serious statute. California courts take it very seriously. Now, in Virginia, it seems like they don't have any specific mechanism for it. They just have this statute that basically says, what we went over earlier, and courts can decide at the very end of the litigation on the on whether or not the defendant is entitled to immunity under the statute, which is weird because the whole point in anti-SLAPP statutes, generally speaking, is to prevent this kind of needless litigation, needless discovery, needless, motion practice. So if in this case there was a determination that, 1 or both of these is entitled to this immunity under anti-SLAPP, it would be kind of let's just say ass backwards for that to be at the very end, because you say, okay, yes, the litigation was pointless, but we've already been through all of that litigation. So then what? Like, there's no preventative measure for it. And in fact, in 2020, Virginia tried with multiple attempts to update the statute for that purpose. There was one bill that came out of the House of the Virginia legislature, and one bill that came out of the Senate in the Virginia legislature, and neither of them passed because they were both a little bit they were both a little bit different from one another. One of them focused on the mechanism, like the specific kind of motion that you can do, and then the other one focused on, I can't remember what exactly, but they for whatever reason the Senate and the House couldn't agree on one method um uh what was I going to say? Like one method of updating the statute so that it kind of makes a little bit more sense. But anyhow, so that's where we're at now with this Virginia anti-SLAPP. So, memorandum of law in support of plaintiff's motion for summary judgment as to defendants' anti-SLAPP immunity. As a matter of law, Ms. Heard is not entitled to immunity from Mr. Depp's claim for defamation under Virginia's anti-SLAPP statute, and her defense on that basis can and should be resolved in Mr. Depp's favor on summary judgment. Ms. Heard has not been named in this action for making a statement on a matter of public concern, and her liability is not, in quotes, solely, in parentheses, or at all, based on a statement of public concern. Quite the contrary. Ms. Heard has been named in this action based on the defamatory implication that she is a victim of domestic abuse and sexual violence at the hands of Mr. Depp. It is that defamatory implication of wrongful conduct that forms the basis of Mr. Depp's claims in this action. And because that defamatory implication relates solely to the personal grievances between the parties and does not rise to the level of a matter of public concern, with broader implications for society beyond the two litigants in this action, Virginia's anti-SLAPP statute is not applicable. So, first off, usually a motion for summary judgment is going to refer somewhat to evidence, but this is basically just sort of this is a motions emotions a motion that is arguing as a matter of law, meaning that it's not going to use really any evidence. Unlike the last motion for summary judgment, which referred to Amber Heard's response to an interrogatory that she didn't really give much of a response. And so therefore Johnny Depp was free to say, hey, then I guess you don't have any evidence to support your claim, which you have the burden of. So therefore you should lose. That's kind of that's the usual argument for a motion for summary judgment. This, on the other hand, is a little bit more like a motion to dismiss. And the reason for that is because anti-SLAPP law in Virginia is weird, in my opinion. In my opinion, this is me coming from California that has a very strong anti-SLAPP law, and it's very strong, and it usually comes very early. And it's much. It has a very specific mechanism that's used. Which in Virginia, it seems much more, let's just say, loosey-goosey. Okay. Part 1, summary of relevant facts and allegations. Mr. Depp's claims in this action were predicated on the defamatory implications about Mr. Depp and Ms. Heard's op-ed in the Washington Post, i.e. the claim that Ms. Heard is an abuse victim who suffered domestic abuse and sexual violence. So, for example, they cite to paragraphs 1 through 2. The op-ed depended on the central premise that Ms. Heard was a domestic abuse victim and that Mr. Depp perpetrated domestic violence against her. As such, the defamation claim at issue relates to the events of the parties' personal relationship and the truthfulness or falsity of Ms. Heard's statements about abuse that allegedly occurred in the privacy of the relationship and marriage. Of note, Ms. Heard's statements did not occur in isolation, but were a revival of prior statements and actions she had taken, including her conduct in walking into court in front of the press in 2016, supposedly with bruises on her face from Mr. Depp, and accusing Mr. Depp of domestic violence and abuse in court filings and in the press. That history is alleged in Mr. Depp's complaint. And then it cites to paragraph 2 of the complaint where they have in quotations, the op-ed plainly was about Ms. Heard's purported victimization after she publicly accused Mr. Depp of domestic abuse in 2016 when she appeared in court with an apparently battered face. End of quote. Ms. Heard openly acknowledges and does not dispute this history. And then it cites to her counterclaim. Paragraph 5. On May 27, 2016, Ms. Heard walked into California State Court with bruises on her face.